there's so many TV shows about litigation, and you've got all the criminal law shows on television. You've got Blue Bloods and Law and Order and NCIS 48 or 56 or whatever it is, or LA, New Orleans, Minneapolis, and so forth, that you hear a lot about the law. We just want to make sure that you're familiar with the terms and you know how the terms are applied. This is a pretty good exhibit right here on the home page for Chapter 4. Is a scale. And in administration of justice, this scale shows one side much lower than the other. And the idea in the legal system is this side that has more evidence should be the winning side. This side should be the losing side because they have less evidence or less arguments in their favor. So that's called the scales of justice. And sometimes in a more elaborate proceeding, they have a statue of a woman holding the scales of justice, and she has a blindfold on because justice is supposed to be blind. It's not supposed to show favoritism because of race or gender or something like that. It's supposed to be a fair fight between the parties. So that's not 100% true, but anyway, we'll talk some more about that as we go through the chapter. Most of you, again, are familiar with the fact that in a criminal case, the state or the locality is the prosecutor. So you have a prosecutor representing the people against the defendant. In civil cases, we call the claimant or the party that brings the case the plaintiff. The defendant is the party against whom the case is brought. Now, when the case is appealed, we change the terminology. The party bringing the appeal is the appellant. That's usually the person who lost at trial court level. And then the person defending the case, again, the party that probably won at the trial court level, is the appellee. Now, these can switch back and forth. So you have party A and party B, and party A wins at the trial court. They go to appeal. Party B wins at the trial court. Party B is the appellant. Party A is the appellee. Then they're still unhappy. So the appellee from the appellate level goes to the Supreme Court of the state or the United States Supreme Court, and they are then the appellant, and the party that was the appellant at the previous level is now the appellee. So it flips back and forth. So it takes some patience. It's not that hard. You just need to kind of pay attention to what the names of the parties, and oftentimes at the beginning of a case, it recites some basic information that helps you get your parties straight. Now, standing is the flip side of jurisdiction. Where we're talking about standing is, do you have a right to be in that courthouse? Not whether the court has jurisdiction, but if you have a right to be there, and that's called standing. Very good example of this in the last couple of weeks was the fact that Texas Attorney General Ken Paxton filed a big case with the Supreme Court to say, we've been damaged because Arizona, Pennsylvania, Georgia fouled up their election system. And so we've been damaged. So we want the Supreme Court to overturn these elections or examine them. And the Supreme Court threw that case out and said that Mr. Paxton did not have standing to sue or to file that particular case. And so that's a standing to sue decision. So what are some of the basics? Well, you have to be adverse to each other. Of course, generally speaking, you're not going to be suing people unless you're adverse to them. At least one of the parties, something in the case must be a legal dispute. If you're mad at your girlfriend because she ripped off your boyfriend, that's not generally actionable. Okay, folks? So it's got to be a legal dispute that we've got a right to go to court. If you get divorced and the dog likes you better than the other person, then that's probably not something the court can fix. So we need to have things the courts can actually fix. And so that's the general idea behind that. Navient lawsuit, we're going to mention this again in a few minutes, is a class action suit. And this company interacted with students that had student loans and didn't do a very good job on behalf of the borrowers. So a federal agency called the Consumer Federal Protection Board, CFPB, got involved and went after these folks. And we're going to talk about why this is an appropriate class action case in a minute. Here we go with class action suit. Remember, we talked about Navient just a moment ago. Here is the standard, and this is something you should commit to memory, spend a few minutes reviewing it. But the basic idea is you can't have a class action unless it's a whole bunch of people. That's the numbers. Typicality is that the people in the case need to be considered as reasonably similar. Commonality is the legal claim across the group needs to be fairly similar. And of course, the argument itself needs to be a reasonable argument, because class actions are a big deal. Most of the class actions that we see today, and you see these ads on television, did you, work in a place that has asbestos? Lots of commercials about people that have illness related to asbestos. You have people that have taken different drugs, people that have had different medical devices implanted. Those are all good examples of class action cases. I can't say that I've ever made out on those. One of the cases that I prevailed on when I lived in Virginia, there's only one electric company in Virginia. And apparently somebody won a big class action suit and said the Dominion Energy in Virginia was overcharging the customers. And they determined, even though I spent hundreds and hundreds of dollars on electricity in this rental house I had, they determined that I was entitled, get this, don't hold your breath, folks, 11 cents. And even more interesting is they decided that they would pay me 1 cent a year for 10 years. I cannot make this stuff up. So class actions don't always produce large rewards. Usually, in these medical cases, some of the people do make out. One of the most common criticisms of class actions is that the only winners in many of these class actions are the attorneys, because the attorneys that got me that 11 cents that I was dying to have probably got a few $1 million out of the case. But again, the individual person that was really the consumer, the person affected by the case, really didn't get much of anything. One of the best known class action cases recently is the Walmart case versus Betty Dukes. Now, in this decision, the Supreme Court threw out a class action case because they said that the case had been improperly structured from the beginning, that there were too many people in the case. This was 1 million to 1.5 million women who claimed that they had been discriminated against and either paid too little or denied promotions and all that. And the Supreme Court said because Walmart has a decentralized human resource system, that it was not easy to determine who did what where and things like that. And they said it's too aggressive, it's too many people in too many different circumstances, that they did not have enough commonality across this large group. Also, they said that because the particular claims were so different, that it would be very difficult to administer this case as a class action. Unlike everybody that took a particular medicine had a particular side effect, that's a little bit easier to figure what can we do for each individual. And so a good example of that, an earlier example, is what are called the breast implant cases. And by the way, Houston, Texas was a center for the breast implant cases. What happened is that starting, I guess, in the 1970s, that women who had had mastectomies, usually due to cancer or concerns about breast cancer, got silicone breast implants to make themselves feel more comfortable, more normal. The problem with the silicone breast implants is that in some cases they leaked, and the silicone caused an allergic reaction in some of the women who were the recipients of these silicone breast implants. Now, that is a relatively modest number of people. However, what happened is, as the popularity of the breast implants became common, a lot of women went in to just get them for cosmetic reasons. And so we ended up with a fairly large number of women who had silicone breast implants. And about that time, they suddenly realized that these were not the safest things for people to have. So the modern breast implant has saline solution in it, so that if the thing does leak, it's not going to be harmful in most cases to the recipient. So in any event, the women that had received the first generation of these implants, there were huge class actions. The best known firm for that was the John O'Quinn firm here in Houston. And O'Quinn, by the way, his name is on a freeway. As you get to Galveston, you're going to see the John O'Quinn breezeway down towards Galveston on Interstate 45. Also, if you're familiar with the University of Houston campus, you're going to see the John O'Quinn Law School building being built over at the University of Houston Law School. And I think there's actually another building over at the Texas Medical Center. So but where he got the money was he was the attorney for these big class action cases against the companies that had designed the silicone breast implants. And I'm not sure if the doctors got sued also, or just the companies that made the implants. But anyway, that's an example, a case that ties into Houston, but that is an example of breast implant case. And again, you can see numerosity, a lot of women were involved. Commonality, the claim was pretty similar, that these women had leaking implants that caused allergic reactions and that they sustained damages. And then there was a system for trying to administer those claims. So anyway, but that gives you some examples of it. A few things to look at on jurisdiction. So we introduced you on Tuesday the general concept of jurisdiction. Here's a little bit more specific consideration. First of all, the court has to have subject matter jurisdiction. That's mostly what we talked about on Tuesday, is that it has to be something that falls within the jurisdiction of that court. Now, in addition, the court has to have personal jurisdiction, meaning it doesn't do you any good to file a case in North Carolina if everybody's in another state and you can't get them to North Carolina in order to respond to the case. So personal jurisdiction is important also. A summons is what is served on you telling you, hey, you've been sued, you need to show up in court. So one of the things is I want to mention to you something that has kind of a colorful name. It's called the long arm statutes. And how this works is, if you're sued in another state, how does that law firm get you into this case? I mentioned to you a real situation which didn't turn into a lawsuit, but could have. When I moved from Richmond, Virginia to Houston, Texas, moved back here in the summer 2013, a friend of mine drove my car and I drove my van down here. While we're driving, a beautiful day like today, we're driving through North Carolina. Actually, it started in Virginia. We went into North Carolina line, past the state line. A weird guy in a pickup truck started harassing my friend. Now, remember, he's driving my car, but he's driving along. He's not trying to play games with this guy, but this guy was very aggressive. And my friend would try and stay away from him, and the guy would maneuver his pickup truck to block my friend. And I'm in the van, which of course I have a high visibility. I'm watching this happening in through my front windshield. But suppose there had been a big car accident as a result of this clown. And so it happened in North Carolina. It would have happened in North Carolina. I'm now a Texas resident. My friend is from Virginia. Suppose, where would you put the case? Well, the case, if this guy caused the accident in North Carolina, the case would probably happen in North Carolina. So in order to get the people there, you would file long arm jurisdiction. And the way that's done is you file the case locally. The local clerk of the court sends it to the Secretary of State. Secretary of State sends it to the Secretary of State in the state where you want the person to be served. And then that Secretary of State sends it to the local courts there to have it served on the person. So that's how you get jurisdiction over people who are not in your court. But remember, the person can also say, hey, I'm not responsible for anything that happened in North Carolina, come get me. Now, one of the reasons you may not want to do that is because if the court awards a default judgment against you, the court may do almost the same thing as the long arm statute, is perfect the judgment in North Carolina, send it up to their Secretary of State, send it to Secretary of State in Texas, send it to the local court here, and enforce that judgment against you here in Texas, judgment from North Carolina. So you need to be aware of the fact that if you've been served and you cannot get out of the case, that you may have to answer the case in another state. Again, that's long arm jurisdiction. In order to get sued, you've got to have minimum contacts. I picked the case of the car accident on purpose, since that would be considered minimum contacts. If you're in a big car accident in a state, yes, you have a valid reason to be sued in that state. And then notice general jurisdiction, defendant resides in the state. That's separate. Specific jurisdiction is what we're talking about in the North Carolina hypothetical, because there was a particular contact in that state, the hypothetical car accident, to cause you to be subject to jurisdiction in that state. So again, that's hypothetical. Fortunately, my friend did not get wrecked by this crazy pickup truck driver. And by the way, how we settled things down is I got him to pull off the road. We went into a rest stop and just chilled for a few minutes. And when we got back on the road, as we're heading down the highway, we saw this guy being arrested by the police. So we were pretty happy about that. So we were glad we got out of the situation without having any automobile damage. And then this is the Bristol-Myers case. It talks about whether you can be sued in California. One of the things to keep in mind is that people like to sue in California because it tends to be a plaintiff-oriented jurisdiction. But if you can get out of being sued in California, that's a good thing if you're a company, because you want to be in a place where you feel like you've got a fair chance of in the courthouse. The Bristol-Myers Squibb case is this decision favor plaintiffs or defendants in this case, and generally speaking, I think it favors defendants in the sense that defendants can avoid being sued in pro-plaintiff jurisdictions. Many of you are familiar with the term venue. It's the Latin word for place. And many of you've heard that term regarding concerts. For some reason, it's very commonly used to say, the concert venue is at the Cynthia Woods Pavilion in the Woodlands. It's very, very, very common statement. So this is a situation under jurisdiction. So in other words, all the courts of Texas have jurisdiction over a Texas case, but Texas is a gigantic state. And so venue is, if you get sued in El Paso, that could be a horrible thing for you. But if everything in the case took place in Harris County, you could do a change of venue to say, hey, judge, this guy did this in order to irritate us or because he thought he was going to be a smart aleck. But we're all here in Houston, and the case shouldn't be filed in El Paso. So what happens is the case does not get dismissed. It just gets moved. It's called a change of venue over to the courthouse in Harris County where it should have been filed in the first place. Most of you know that, when you're filing in court, we mentioned briefly that it's an indictment in criminal court. In civil court, it's called a complaint or a petition. This particular set of slides says complaint. I usually use the term pleadings or petition, which are in the same idea. If you've been sued, it's important to file an answer within the time limit. Here in Texas, it's generally 20 days after the first Monday. So it gives you about 25 days approximately to file to a case. And then if you're sued, you can also file a counterclaim saying, oh, well, they think they owe me, I owe them money. Well, wait till you see this. They owe me a bunch of money anyway, and that's a counterclaim. I mentioned before about a default judgment. You do not want to take a default judgment. Hard to get around that, and that can be enforced against you. You never had a chance to defend yourself. One of the ways that you can deal with a case that's filed against you that's a bogus case is to go to the judge and say, Judge, we want a motion to dismiss. We want to get rid of this. And this what happens if it's not a proper action, if the court does not have jurisdiction. And especially important is what most attorneys acronym is SL. And it's usually written, if you're taking law school notes, it's S/L, statute of limitations. Virtually every legal claim has a statute of limitations. There are some exceptions: treason, kidnapping, murder, serious crimes like that do not have a statute of limitations. Virtually every civil complaint has a statute of limitations. Usually it's 1 year for defamation, 2 years for most tort claims, 2 years for written contracts. 2 years for oral contracts, 4 years for written contracts. Those are some pretty common statute of limitations. There's a variety of devices used in discovery. This is where a lot of time and money is spent getting a case ready for court. Interrogatories are written questions. They're served between the parties. Subpoena is to require someone to appear at a deposition. And then depositions are expensive, so that you don't do this for everybody, but a deposition is designed to get people who are to produce information regarding the case at hand. Either the parties or witnesses are deposed. And this is usually expensive because you've got to pay a court reporter to be there. All the attorneys need to be there, and so forth. Now, there are two things that are not in this list. One of the most common ones is called a request for production, acronym RFP. And request for production is to say, you produce to us every document that you could possibly get that relates to this case. And of course, today that includes electronic records and things like that. And then another one that you don't see very often is called requests for admissions. And these are served on the other side. Oftentimes this is used on parties that do not have an attorney. They're doing the case themselves. That's called pro se, from the Latin for yourself, pro se. And in the request for admissions have to be returned and signed within 30 days, or they're deemed admitted. So one way to harass or beat up on a pro se party is to send them admissions like, you agree that you have no case, you agree that you didn't do anything that you were supposed to do, you agree that we win the case, and so forth. So I know it sounds a little simplistic, but admissions have to be very, very carefully written, because each admission has to contain only one assertion of fact. So you have a lot of really short things. You are male. You were born on February X 1952. You were in a car accident on this date, and things like that. So it's very simple, but again, it helps you to get where you want to go. In terms of jury selection, I mentioned in the earlier class that there's a TV show starring Mark Harmon called NCIS. And in that show, Mark Harmon himself starred as the lead character. And the number 2 character in that show for many years was Michael Weatherly. And he left NCIS several years ago to star in a TV show called Bull, B-U-L-L. And the idea of Bull is that he is a jury consultant. Now, the problem with the show is that he acts like a Perry Mason and a insurance investigator and a coach for the parties and all sorts of crazy stuff that has nothing to do with being a jury consultant. So, but in any event, there's actually a TV show. I think it's still running. I don't know if it is. Terrible show. But the idea is that he helps people pick juries who are more likely to rule in favor of the client who hired the jury consultant. That's completely legal. It's a legitimate thing. For most of us, we pride ourselves on being able to pick a good jury. So most of us don't use consultants. Also, it's expensive to use a jury consultant. So it's more likely to be used by a rich person who say is up on criminal charges but can afford to pay a jury consultant and maybe help them get off on the case. And then you've also got a situation where in civil cases where there's millions of dollars at stake, it may be worth it to hire a jury consultant to make sure that on the jury, like if it's a medical malpractice case involving a device, that you don't have people on the jury who've lost a family member or are really rabidly against a medical manufacturer. So you want to try and weed those people out. And that is called the voir dire. Voir dire is the correct pronunciation. It's rarely used in Texas. You're going to hear, here in Texas, you're going to hear every pronunciation under the sun for voir dire. And then can you get rid of people? Number one, if someone expresses an obvious bias while you're doing the voir dire, you're asking them questions and they say, well, I hate people who look like this, or I hate businesses or something. Usually you can go to the judge will throw that person off the jury. And then there are something called peremptory challenges. Most of the time, each party gets 2 or 4 free, basically get out of jail free cards to object to people on the jury that you feel would be against your case, but that you cannot express a for cause reason to get them off. And it's been determined through case law that at some point, public prosecutors would exclude people if there was a person of color accused of a crime. The prosecutors would go in and remove everybody who was that color from the jury. And subsequently, it's been determined that created an unfair jury. So you cannot strike jurors on the basis of their racial identity. Now, if they say something racist and you feel that they would be very unlikely to make a fair decision, certainly you could exclude people on the basis that they were racist, but not on the basis that they belong to a particular color. So something to think about. But again, for cause or peremptory challenges. By the way, when I did do trial work, I found that it's very hard to get the judge to take people off the jury panel for cause. So the judges don't like to do it, and they're like, "Well, you got peremptory challenges. Use those peremptory challenges. Don't look to me to bail you out." Jury instructions are very technical and designed to keep the jury up to date on what they need to do. Verdict is a decision of a jury. If you're having what's called a bench trial, which means the judge is sitting without a jury, then that will be simply a judgment. Again, it's very expensive to have litigation. It's very expensive to go to trial. So even after you've done all that expensive discovery, you're still trying to get rid of the case. So you may go to the judge and ask for judgment on the pleadings. That's not usually successful. Now, below it is a motion for summary judgment. The acronym for that is MSJ, motion for summary judgment. And this is when there's been depositions, there's been a lot of evidence produced, and one of the parties will go in and say, "Judge, look at all of this stuff. There's just no case here, and you need to throw this case out." Doesn't happen very often, but it is useful to do that, go through that discipline. And so obviously you've got to prove your case. And we talked about those scales of justice at the beginning of this chapter. So you need to be careful. I'm not going to spend much time on this other than to say that in these cases that you're going to hear objections. If you watch any episodes of Law and Order where they show the trial scenes, you'll hear people jump up and say, "Well, that's a leading question," or leading the witness or something like that, and redirect and so forth. Now, in terms of producing evidence, the side that brings the case. So in criminal cases, as many of you know, you're innocent until proven guilty. The state has to bring evidence forward to prove that you're guilty. In a civil case, the side that wants to prove a point has to prove that point. And so for criminal cases, it is beyond a reasonable doubt. In civil cases, it's the preponderance of the evidence. And in your lifetime, this may be the only time you see the word preponderance. It's almost always just used to talk about the burden of evidence in a civil case. Motion for directed verdict follows the presentation of the plaintiff's case. So for instance, the case, they spend 2-3 days presenting the plaintiff's case in all of its glory. And then the defense attorney stands up and says, Judge, these guys didn't prove a thing. It's a stupid case. They're losers. We want you to give us a motion for directed verdict. It doesn't happen very often, particularly with a jury trial, because the judge doesn't want the jury to be mad at him, saying, here, we were brought in, we spent all this time here, and we didn't get a chance to make a final decision. So oftentimes a motion directed verdict is a difficult one to bring forward. We have acronyms for both of these post-trial motions on slide 26. Motion for a new trial, attorneys just say MNT. So you hear attorneys saying MNT, he probably lost at the trial level, and it's kind of automatic. Very rarely is an MNT granted, but it's pretty automatic to ask for one. Then a motion for judgment notwithstanding the verdict is usually for similar reasons. You've lost the case and you're mad about the jury. And so it's actually called JNOV. What that stands for, judgment non obstante verdicto. That is Latin for judgment notwithstanding the verdict. So you'll hear attorneys say JNOV or MNT following a case that they've lost. Or they're defending a claim, one of these two, because they won the case and the other side's filed these against them. A matter of right is, generally speaking, a death penalty case. You have an automatic right to appeal your death penalty case. Discretionary, pretty much everything else. The appellate courts have a variety of weapons in their quiver. They can affirm, they can reverse the prior court's decision, or they can remand. Usually, if the appellate court sends a case back to trial court on a remand, they give them instructions. They say, well, here's what we think you did wrong the first time, fix it this time.